Good morning, Your Honor. I am baffled by this hearing today, where the opposing parties have instructed their counsel to compel arbitration. I have been requesting arbitration, mediation, and any form of problem resolution from HICV, the sales managers, owners support online and phone support, resort management, their financial department, their legal department, directly offered to Ms. Viciano, their online sales director. May I ask the opposing counsel why his clients refuse arbitration repeatedly and now wants to compel arbitration? While the state of South Carolina is mandatory arbitration, I respectfully request to proceed with non-binding arbitration unless counsel has come with a proper offer to settle from his client. Mr. Lawson. Brief summary: in 2021, plaintiff and her partner vacationed at Orange Lake, Florida, where they agreed to attend a sales tour. Due to ongoing pandemic conditions, the offer presented appeared especially appealing. At plaintiff's request, her partner purchased 150,000 points in lieu of a wedding celebration and ring, though after the purchase, plaintiff discovered that the promises made during the tour did not align with the terms in the written contract. Plaintiff and her partner took out a loan at the time of purchase on September 27, 2021, which was paid in full and closed by October 2021. Plaintiff was then instructed to transfer all points into her name alone, a process presented as a simple clerical task. Despite repeated calls over the next year, plaintiff was told the transfer could only be completed in person at a sales center, with both parties present. Plaintiff scheduled a stay from July 7, 2023, at the Myrtle Beach, South Carolina resort and booked an appointment with the sales department for what was described as an owner's update. Plaintiff clearly informed both the online representative and resort staff that the purpose was solely to transfer existing points into her name and that no additional purchases would be made. Plaintiff reiterated that the original purchase was a gift, and due to the significant discrepancies between the sales presentation and the written contract, no further transactions would occur. On July 8, 2023, plaintiff and her partner signed documents they were told were solely for the transfer of points into plaintiff's name. They were not provided a copy at the time and were told that one would be mailed to them, which never occurred. In September 2023, plaintiff and her partner received a billing statement from HICV with minimal detail, instructing them simply to log in and make a payment. Believing it may have been related to maintenance or fees, they paid it and immediately contacted HICV for clarification. After numerous calls and conflicting explanations, plaintiff was finally informed that the charge was for a new loan, despite never having applied for or authorized one. Plaintiff and her partner were later told that Holiday and Club Vacations South Carolina sales team had used prior documents from the closed and fully paid account to unlawfully generate the new loan. This conduct constitutes identity theft and fraud under federal law, including 18 U.S.C. 1028, and violates 15 U.S.C. 1632 of the Truth in Lending Act, which requires clear, written disclosure of loan terms before execution. No such disclosures were provided. Plaintiff was also informed that their previously paid-off points had been sold back to Holiday and Club Vacations. This sale was made without the plaintiff's prior knowledge or consent, and to date, no documentation substantiating this alleged sale has ever been provided to the plaintiff. The absence of any written agreement, confirmation, or record of transfer raises serious concerns regarding the legitimacy of this claim and points to potential fraudulent activity by Holiday and Club Vacations and its agents. It is important to note that the Holiday and Club Vacations sales manager on duty during the July 8, 2023 presentation was Mr. Howard Tews. Public records confirm that Mr. Tews was previously convicted of mortgage fraud in 2014. According to information released by the South Carolina State Attorney's Office, he was sentenced to jail and ordered to pay restitution as part of his conviction. This raises serious concerns about Holiday and's hiring practices and the integrity of their sales operations, particularly in light of the deceptive conduct the plaintiff experienced during that same sales meeting. Additionally, the conduct of sales agent Allison Farinola during the July 8, 2023 meeting was erratic and confusing. Despite the plaintiff's repeated and unequivocal statements that no purchase would be made, Ms. Farinola persisted in presenting handwritten scraps of paper with varying figures, each time asking if the amount was okay. The plaintiff consistently responded that they were not making a purchase and that the numbers presented were irrelevant. Ms. Farinola's failure to comprehend or respect these clear boundaries raised serious concerns regarding her mental capacity or fitness to perform in such a high-pressure sales environment. Due to this behavior, the plaintiff requested on 3 separate occasions that another sales representative be assigned to assist, but no such accommodation was provided. To make matters worse, Ms. Farinola began directing undue pressure toward my partner, repeatedly challenging his statements that we were not interested in making a purchase. Her behavior escalated to a level that was unprofessional and aggressive, disregarding our expressed boundaries. Rather than respecting our clear position, she attempted to wear down our resistance by redirecting her focus onto my partner, creating an uncomfortable and confrontational atmosphere.